Hello, fellow toolboxers. Welcome to the show. This week, we're doing our regular Monday top 10 things that matter the most for immigration lawyers. And that, I learned this week I want to share a hodgepodge of different interesting points that happen in the immigration game. There's always in the last couple of weeks more than 10, and I do some bonuses or I just save stuff for next week. But the insanity of being an immigration practitioner continues. So let's jump into the show. First, before we start, I want to thank a special sponsor that we have for the show. This episode is brought to you by San Antonio IT Solutions. San Antonio IT Solutions helps law firms protect what matters most: your data, your clients, and your reputation. Cyber criminals are getting bolder, and let's be honest, most law firms aren't built to keep up. Whether it's ransomware, phishing, or someone accidentally clicking the wrong link, one small mistake can cause a big mess. That's why they focus on cybersecurity first and then layer in smart AI tools to help your team work faster and safer. San Antonio IT Solutions doesn't just fix things when they break, they help prevent the chaos in the first place, even if you already have an IT person or company. Visit sanantonioit.net, that's sanantonioit.net, to see how they protect modern law firms from modern threats and use AI to give you a real edge. Thank you for them. I met them at the AILA conference in Colorado this year, so it's a good introduction. I have a short video I did with them too, talking about their software, what they do, and on my LinkedIn page, primarily YouTube too, where I did 40 or so videos with local vendors there. One more note is our community page is growing on circle.so. This is where we trying to get off Facebook to share information. Plus, there's a lot of free content there. It tends to help you become a better practitioner for immigration lawyers only. Non-immigration lawyers are not there. There's white label content in my law firm's marketing and materials to give to our clients, courses and free courses, for example, on how to do 245i, this and that. Plus our premium courses. I've launched the EB1A course, how to do extraordinary ability cases, last month. And big announcement, we just released our E2 initial investor program as well. These are the E2 cases that I do, where it's a small-time investor, less than $100,000. They're going to own and operate the business. How to do premium processing, not premium processing, consular processing. How to do change of status. How the regulations of the FAM work, Foreign Affairs Manual, work in this context, along with samples of how these cases look like, so you're prepared and you're not nervous about it. You say, okay, I see how it works. It takes the mystery off it. So these are available if you're already a member of the Circle.so community page. They're on the left side of the screen. You could click on them, and there's a purchase right there. If you're not a member, please send us, and you want to join, please send me your bar information first, because it's lawyers only for these programs, and we give you access and information about how the course works and all that kind of stuff. Having said all that, all the information provided here is not intended as individual legal guidance. Please consult with an immigration attorney about your case, but you all know that already. So let's get started. Now, a quick note: I'm getting better at giving show notes. So if you go to our YouTube page or the podcast page for this, I'm going to have links to the things that most of the things I talk about, so as a reference. But this starts with number one. Our colleague Samir Kedekar, I've been talking about him last couple weeks on the show, because he's seeing a lot rise in NTAs for H-1B people who are doing H-1B transfers in the middle of the transfer, because the initial employer terminates H-1B. All of a sudden, they lose their status and they get NTA'd. So that's a terrible situation, but it's also happening to family members. If the H-1B is even approved for the primary, the H-4s, if they're not timely filed or doing nunc-pro-tunc, they're getting NTA'd, which wasn't perfectly out of the norm, but one of our colleagues responded to his post on LinkedIn, Gianfranco, which actually is going to be on the show, doing a podcast with him very soon. Said husband's H-1B has an example. H-1B is approved, H-4 remains pending, and 2 weeks ago was placed in removal proceedings. Interestingly, served a biometrics notice for the NTA. Never seen that before. So a lot of weird stuff is happening in the H-1B, H-4 space. If you're changing employers, you're doing a switch, these things are going to be potentially happening. Number two, from Jeff Joseph, the AILA president this year. Congrats to him. He posted in a recent development in administrative and federal litigation. So it's a little bit different than pure immigration law. But the Third Circuit made a significant ruling in the case of Sun Valley Orchards LLC versus DOL, Department of Labor. The court determined that the Department of Labor judges do not have the authority to preside over H-2A wage and hour disputes. The decision stemmed from a 2024 U.S. Supreme Court ruling in SEC v. Jarsky, which established that individuals facing civil liberties are entitled to a jury trial under the Seventh Amendment before fines can be imposed. And he writes, recent actions by the Department of Homeland Security have seen the issuance of letters and attempts to impose penalties reaching as high as $1.8 million on individuals accused of willfully remaining in the U.S. after a final order of removal. We've seen these posted on Facebook too in different groups where people are getting $1 million notices to pay for overstaying. DHS cites authority under 8 U.S.C. Section 1324 DF1, allowing for civil penalties of up to $500 per day without the need for a trial. The rooming question arises, he writes, will these penalties withstand scrutiny under the Jarsky ruling? If you are a business or individual facing fines from an administrative agency and you want to challenge them, reach out. So he's gone into, I think he's like partner in litigation at BAL. So he's going real hardcore at it. He does real cool litigation. I've had him on the show before. He had some interesting stuff. Those there's some sort of green card situation for people in the Pacific Islands and stuff like that. That's like rare, but he was like on top of it and stuff. So interesting stuff. Number three, I started following a person. His name is Andrew Kreebaum. He's an immigration reporter at Bloomberg. He posts a lot of interesting stuff, so I'm getting a lot of info from him. But he shared an article from NPR.org written by Jimena Bustillo, saying the Trump administration has sought to block dreamers of healthcare and education benefits in recent months without issuing new regulations. Connecting the dots in a quiet effort to pressure DACA, Himana thinks of female. Right, she writes to leave the country by chipping away at the program. Homeland Security SPOX Trish McLaughlin says the administration doesn't consider them DACA holders who hold deportation protections. Quote, DACA does not confer any form of legal status in the U.S. In this country, she claims. Texas challenging, I'm sorry, it's early in the morning recording this. A Texas lawsuit challenging DACA regulations is still pending at the Fifth Circuit, and there are problems like, for example, the Health and Human Services Department said it will make DACA recipients ineligible for the federal health care marketplace in June. Then last week, the Education Department said it was looking into 5 universities that offer financial help for DACA recipients. Also, immigration enforcement officers have arrested and detained DACA recipients throughout the country, which immigrant advocates say weakens protections of this group. So the DACA protections are not as solid as we would think they were going to be. They say it's deferred action, but it's not status, so it's not. It's deferred action, but it's not deferred action. It's better to have than not to have. I recently got a deferred action AP approved. By recently, I mean like last week in Southern California. It took about a week after the interview to get approved. I think because the computer broke during the meeting or something, but during the interview. But every day is a new day in this game. Number 4, weekly ChatGPT errors. So every week, the last couple weeks, I bring you errors I've seen with ChatGPT and their analysis of immigration law. I kind of double check my work. In particular, in this case, I'm going to go over. I don't typically do a lot of widower cases, but I had a person contact me who had an I-130 pending and spouse died, and they're wondering what to do. And I recall that you could directly file these with the embassy because I had a case, I think it was in Sweden, where the spouse died even before we filed the I-130. We were about to file, but the spouse died, and the applicant returned back to the home country, and we directly filed with the embassy. So I typed in ChatGPT, how do we directly file with the embassy or what the situation is? And ChatGPT specifically said, no, it cannot be filed with the embassy. It has to be 100% by USCIS. And so I kept going back and forth and telling it. Eventually, I found the email where he contacted Sweden, and I copy pasted. I'm like, hey, this is what Sweden says. Like, oh no, there is an exception, this and that. So ChatGPT, it helps legal stuff. If you already know the answer, you can force it to get to the answer. But general users should not be using ChatGPT AI as of this day, August 4th, 2025, as pure immigration guidance because just way too many errors and weekly I'm seeing it. It's probably going to eventually get it fixed, especially because I'm correcting it constantly if it keeps track of my corrections. But tell clients do not rely on clients not gonna believe you. I think you're trying to charge them money or something like that. But you cannot rely on ChatGPT. The guidance has glaring errors in it. Number 5, this is a post by James Hollis, heavy in the consulate game on LinkedIn. He commented. Actually, it was a post by the U.S. Consulate General in Mumbai, and it's really nasty the way just the way they're portraying America overseas. So they posted on LinkedIn that the U.S. This is a post by the embassy, just out of nowhere. They just post this. U.S. national security is our top priority. Every traveler undergoes extensive security screening, including checks against law enforcement and counterterrorism databases. Your visas won't be issued until all security concerns are fully resolved. Prohibiting travel by those who might pose a threat is key to protecting U.S. citizens at home. And then they have this image that says if you overstay your visa, you could face a permanent ban on travel to the United States, as well as criminal prosecutions. Consular officers have full access to your immigration history and will know about past violations. There's no such thing as a quote unquote honest mistake. It's just facially wrong on it because there's no permanent ban necessarily for overstaying. I mean, you got a permanent bar is a different thing, and it's not really that permanent. If there's criminal prosecutions, probably not. And, that's not an honest mistake situation. So it's just the way they put it. It's so aggressive. But I was going to put this as a bonus actually at the end. I'm going to share this now to add to the horrors of everything that's going on. There was a leak of a memo that was published in newrepublic.com. It said it's titled Trump Military Anti-Immigration DHS Leaked Memo. Essentially, they want to bring more and more troops into the United States. And they're couching it, the language, as if it's all about Al Qaeda, ISIS, and dangerous stuff like that, which probably does exist to a certain extent. But the militarization, I think, goes deeper and has different, in my opinion, has different needs and goals. They write in the New Republic, the memo suggests that DHS is anticipating many more uses of military in urban centers, noting that LA-style operations may be needed for quote-unquote years to come. And it likens the threat posed by transnational gangs and cartels to having Al Qaeda or ISIS cells and fighters operating freely inside America, hinting at a ramped-up militarized posture inside the interior. The memo is alarming, is a quote from the article, because it speaks to the intent to use the military within the United States at a level not seen since Japanese internment, quote unquote, close. Carrie Lee, senior fellow at the German Marshall Fund, told the author, the military is the most powerful coercive tool our country has. We don't want the military doing law enforcement. It absolutely undermines the rule of law, quote unquote, close. The memo was authored by Philip Hegseth. So this is the younger brother of the Defense Secretary, Pete Hegseth, who is a senior advisor to Homeland Security Secretary Kristi Noem and DHS liaison officer to the Defense Department. Good times. As such, it also sheds light on Hegseth, the younger's role, which has been the subject of media speculation, labeling him as an obscure but influential figure in his brother's MAGA orbit. Due to the sensitive, quote unquote, due to the sensitive nature of the meeting, minimal written policy or background information can be provided in this briefing memo, the memo says. So I'll have a link to that New Republic article. Pretty scary stuff. The worry is always Japanese style tournament coming back. So hopefully it doesn't. Especially my ethnic background, that's a big worry if war starts with Iran and stuff. That's what I've been worried about since for the last 20 years, and seems like it's getting closer. So let's see what happens. I'll bring the news to you. It might be one of the last pieces of news I bring on this show. Number 6, multi-jurisdictional disbarments. So this is an interesting post by Nikki Black. North Carolina disbarred a lawyer who wasn't active, who wasn't part of that state, but the state bar appeals took it out. So this is the fact of what happened. An attorney was licensed in New York, not North Carolina. He practiced federal immigration law from a Charlotte-based firm. He maintained a trust account registered in North Carolina's IOTA program. He ignored a grievance and was disbarred by North Carolina Bar, or DHC, I'm not sure what that stands for. Then he appealed on jurisdictional grounds and won. The court concluded that North Carolina's disciplinary statutes only apply to lawyers, attorneys licensed in the state. Federal practice and local presence, not enough. So that's an interesting thing going on right there. A lot of immigration practitioners practice in other states. Now, it's probably a state-based thing, but you get away with murder in North Carolina. So we'll see how that goes. I'll take a quick second to remind everybody and to just bring it back up, frankly, that the EB1A and E2 seminars are out. If you want to become an EB1A lawyer, you want to learn how to do E2 cases, expand your practice, go into business space, and these are great because they don't need employers, these kind of cases. Our E2 seminars, investor owner, less than $100,000 investment. They allow you to have clients that don't need employers. They contact, say, hey, what could I do? Like, well, you have extraordinary ability. Hey, you got some money to invest out of business. This is how you do it. We have the seminars for you. They're training videos plus office hours. So you could talk with me, ask questions, and get into this space. Ask anything you want during our office hours times about marketing, about business, anything I'm doing. As y'all tell from watching the shows, I'm pretty open about talking about stuff. If you're interested and you want to learn more, you have to be a lawyer. But email me at info@immigrationlawyerstoolbox.com. That's info@immigrationlawyerstoolbox.com. Let's get back to the show. Number 7, Trump administration orders massive expansion of GPS ankle monitors for immigrants. All the pieces of news are terrible. I just wish I had better news. So that's this week in immigration. A troubling new Washington Post report reveals that Trump administration has quietly ordered Immigration Customs Enforcement to dramatically expand the use of GPS ankle monitors, potentially shackling an additional 160,000 immigrants with electronic tracking devices. According to internal ICE memo dated June 9th and obtained by the Washington Post, the ICE agency has directed staff to place ankle monitors on all people enrolled in its alternative to detention ATD program whenever possible. This represents a sharp departure from recent trends and a return to the more punitive surveillance technologies that defined earlier eras of immigration enforcement. There's more written there, but I'll leave it at that. It's a crazy situation. Number 8, I mean, you play devil's advocate, you want to track people and this and that, but the people who are coming to their ICE appointments are the people who are not going to be, those aren't the ones that are the problem that need ankle monitors per se. Number 8, colleague got natural. Okay, so we had a post from a great colleague of ours who locally here and who had a NATS case, amongst other reasons, she said, but they tagged on a good moral character adultery reason for the denial for naturalization, or at least a notice of intent to deny. It's not typically see that, and it wasn't even in the, she said in the 5 year, it was 15 years earlier. And again, there's other issues, but they tagged in adultery. So I pulled up the policy manual for naturalization. It says adultery is still there. An applicant who has an extramarital affair during the statutory period. So if you can't just, it has to be statutory period, that tended to destroy an existing marriage is precluded from establishing good moral character. And then there's an extenuating circumstance part. It says if the applicant shows extenuating circumstances, an offense of adultery should not adversely affect the GMC determination. Extenuating circumstances may include instances where the applicant divorced his or her spouse later, but the divorce was deemed invalid, or the applicant and the spouse mutually separated and they were unable to obtain a divorce. So that's scary because I have a case right now, and the person is in a foreign country, and the courts are so backed up over there. They started a divorce process 24 months ago, and it still has that's just pending. So they don't live together; they're just over, and they met someone new. And I was like, oh, is this a problem? Because they might say there's adultery, but there's no adultery here. Spouse separated, and they're unable to obtain a divorce because they have documentation of the date they filed it. 2 years have gone by. They're still, like, the courts are backed up. And so I don't think it's an issue, but it just brings up these things, the extra things to worry about. Number 9, court saves protections for Central American Nepalese immigrants. A federal judge in San Francisco granted a request to postpone the Trump administration's cancellation of temporary protections for 60,000 immigrants from Honduras, Nicaragua, and Nepal. They're safe for now. And number 10, false claim possibility. So with the new executive order on birthright citizenship, if it ends up going through, it's going to mean that every client who doesn't have who not born a citizen, or was born a citizen even, but they need to have an N600 submitted to get a certificate of citizenship, where they became a citizen because their parents did before the age of 18, or they're born abroad and they got a passport, no consular record of birth abroad, but got a passport. Even if they got a consular record of birth abroad, it's probably better to get N600 for pretty much everybody nowadays, even if this doesn't pass, just to be safe. We really have to be pushing this on clients to file the N600, because in the future, especially if this executive order goes through, how could you change the fundamental things such as birthright citizenship by executive order and legislature try to do it? I don't understand. We'll see what the courts say, but that doesn't make any sense to me. But I'm sure a lot of people think the same way. Because it's going to be a problem in the future, too, for I-130 petitions, maybe 18 years in the future. But they're going to, right now, use a birth certificate, for example, but we can't use just birth certificate anymore if that's the case. So that's a weird one that's coming up. And then number 11 bonus, a shout out to Taylor Levy at zealousimmigration.com. She does a lot of this border type work. And she announced that there's a case called CHIRLA v. Noem, saying big news today for non-citizens who applied for admission at a port of entry, land, port of entry, or airport, and were paroled at the port of entry to POE. They cannot be subject to expedited removal according to this CHIRLA v. Noem case. I haven't read it, don't know much about it, but I want to put it on your radar. She says she's going to write more about it, but she's out right now. CHIRLA, this is the organization that helps immigrants. V. Noem, Christy Noem, is a case. So if you want to look that up, and I got to look it up too. I probably have one case like this. But some important stuff out there. Again, thanks for Taylor Levy for announcing that. zealousimmigration.com, info@zealousimmigration.com. So her email. She helps a lot of training, and she has her own community page as well for these kind of cases. Well, thank you so much, everyone who's listening again. I love talking about immigration law, and I record these in the mornings, which I'm just still waking up. It's like 6:45 in LA, but I think it's a good start to the week to force myself to get up and talk about immigration law. So my speaking isn't the best because I'm still waking up. My cup of tea is here. I still haven't touched it. But nonetheless, I think it helps me, and it might help you too to get your week started. Hear me fumbling around and this kind of stuff might be some good humor to it. If you want to get to EB1A, if you want to get to E2, expand the practice, I got the course for you. Email me at info@immigrationlawyers.com. I'll send you information to become a better immigration practitioner, expand your practice, expand your team, and just live the good life as much as you can. Practice immigration law. God bless. Be safe. I'll see you all next week. Bye bye.